Cpc Takwani. Civil Procedure, 6th edition, Lucknow. The more you study Civil Procedure Code, the more you realize what an admirable piece of legislation it is. The Code of Procedure must be regarded as such. It is procedure, something designed to facilitate justice and further its ends, not a penal enactment for punishment and penalties, not a thing designed to trip people up. Index. Preliminary 1. Introduction. 2nd. Definitions. Part 2. Suits. Suits law. Jurisdiction of civil courts. 1. 2 is res sub judice and res sub judicata. Res judicata. 3rd is foreign judgment. 4th is place of suing. 5th is institution of suit. 6th is pleadings. 7th is plaintiff and written statement. 8th is appearance and non-appearance of parties. 9. First hearing. 10. Discovery, inspection and production of documents. 11. Interim order. 12. Withdrawal and compromise of suits. 13. Death, marriage, insolvency of parties. 11. Trial. 15. Judgment and decree. 16. Special suits. Part 3. Appeals, reference and review and revision. 1. General. 2. First appeal. 3. Appeal. Second appeal. 4. Appeals from orders. 5. Appeals by indigent persons. 6. Appeals to Supreme Court. 7. Reference. 8. Review and 9. Revision. Part 4. Execution. 1. Execution in general. 2. Courts which may execute decrees. 3. Application for execution. 4. Stay of execution. 5. Mode of execution. 6. Arrest and detention. 7. Attachment of property. 8. Questions to be determined by executing court. 9. Adjudication of claims. 10. Sale of property. 11. Delivery of property. 12. Distribution of assets. Part 5. Miscellaneous. 1. Transfer of cases. 2. Restitution. 3. Caveat. 4. Inherent powers of the courts. 5. Delay in civil litigation. Appendices. A. Plaint. B. Written statement. C. Issues. D. First appeal. E. Second appeal. F. Revision. G. Injunction application. H. Affidavit. I. Caveat. Subject index. Part 1. Preliminary. 1. Introduction. 1. Procedural law. 2. History of the code. 3. Commencement. 4. Consolidation and codification. 5. Extent and applicability. 6. Object of the code. 7. Scope. Code not exhaustive. 8. Interpretation. 9. Scheme of the code. 10. Retrospective operation. 11. Code at a glance. 11th page. 2. Definitions. 1. General. 2. Important definitions. Antlo 1. Decree. A. Meaning. B. Essential elements. Antlo sub 1. Adjudication. 2. Suit. 3. Rights of parties in controversy. 4. Conclusive determination. 5. Formal expression. E. Test. D. Decisions which are decrees. Illustrations. E. Decisions which are not decrees. Illustrations. Classes of decrees. F. I. Preliminary decree. Final decree. Partly preliminary and partly final decree. Definitions. 1. Deemed decree. Meaning, nature and scope. Decree and deemed decree distinction. Deemed decree under CPC. Rejection of plaint. Restitution. Execution. Dismissal for default. Appealable order. Decree and judgment distinction. Decree and order distinction. Decree and deemed decree distinction. Judge. 2. Next is 2. Judge. 3. Mean judgment. A. Meaning. B. Essential. C. Judgment and decree distinction. 4. Order. A. Meaning. B. Order and decree similarities. C. Order and decree distinction. 5. Decree holder. 6. Judgment debtor. 7. Foreign court. 8. Foreign judgment. 9. Legal representative. 10. Mesne profits. A. Meaning. B. Object. C. Against whom mesne profits can be claimed. D. Assessment. C. Test. J. Principles. G. Illustration. H. Interest. I. Deduction. 20. Public officer. 3. Other important terms. 10. Affidavit. 2. Appeal. 3. Cause of action. 4. Caveat. 5. Civil. 6 court, 7 defendant, 8 execution, 9 issue, 10 jurisdiction, 11 plaint and 12 plaintiff. 11 is 13 suit, 14 summons, 15 written statement. Part 2 suits. 1 jurisdiction of civil court, 1 general. 2 jurisdiction meaning, jurisdiction and consent, lack of jurisdiction, irregular exercise of jurisdiction, basis to determine jurisdiction, jurisdiction fact, decision as to jurisdiction, courts and tribunals, jurisdiction of foreign courts, kinds of jurisdiction, civil and criminal, territorial and local, pecuniary, based on subject matter jurisdiction, original and appellate jurisdiction, exclusive and concurrent jurisdiction, general and serial jurisdiction, legal and equitable jurisdiction, municipal and foreign jurisdiction, expounding and expanding jurisdiction, jurisdiction of civil courts. Next, section 9, conditions, sum of civil nature, suit of civil nature, meaning, nature, scope, doctrine explained, test. Suits of civil nature, illustration, suits not of civil nature, illustrations, cognizance, not barred, suits expressly barred, suits impliedly barred, who may decide, presumption as to jurisdiction, burden of proof, objection as to jurisdiction, exclusion of jurisdiction, limitations, exclusion of jurisdictions of civil court principles and general principles. Rest, part 2, res sub judice, res judicata, 1 general, 2 res sub judice, stay of suit, section 10, then 1 section 10, 2 nature and scope, 3 object, 4 conditions, 5 test, 6 res sub judice and res judicata, 7 suit pending in foreign court, 8 inherent power to stay, 9 consolidation of suits, 10 contravention effect, 3 res judicata, section 11, 1 general, 2 section 11, 3 nature and scope, 4 object, 5 illustration, 6 history, 7 extent and applicability, 8 res judicata and rule of law, 9 res judicata and res sub judice, 10 res judicata and estoppel, 11 res judicata and stare decisis, 12 res judicata and splitting of claim, 13 res judicata whether technical, 14 section 11 whether mandatory, 15 section 11 whether exhaustive, 16 interpretation, 17 waiver, 18 conditions. Again J, matter and issue. 1 I matter and issue. 1 general, 2 meaning, 3 classification, 4 matter directly or substantially true, explanation 3, 5 matter actually in issue, 6 matter constructively in issue, 7 constructive res judicata, 8 might and ought, 9 matter collaterally incidentally in issue, 10 matter directly substantially and matter collaterally. Distinction, 11 findings on several issues, 12 finding on matter not in issue, 13 suit meaning, 14 former suit, explanation 1, 15 issue meaning. Res sub judice and res sub judicata. If same parties, general, illustrations, party meaning, res judicata between co-defendants, res judicata between two co-plaintiffs. Pro forma defendant affidavits minus parties under when they or any of them claims representative suit, explanation 12, 11 conditions, 12 public interest litigation, 3 same title, 1 general, 2 meaning, 3 illustration, 4 test, 5 competent court, 1 general, 2 object, 3 competent court, general, object, competent to court meaning, explanation, out of court settlement. Court of exclusive jurisdiction, court of limited jurisdiction, court of concurrent jurisdiction, test, right of appeal, heard and finally decided, general, nature and scope, decision on merit, necessity of a decision, finding more than one issue, right of appeal, relief claimed but not granted, execution proceedings, industrial adjudication, taxation matters, public interest litigation, criminal proceeding, writ petition. General doctrine, summary, constructive res judicata, habeas corpus, general principles, dismissal for default, dismissal in limine, dismissal of special leave petition, ex parte degree. Next to res sub judice and res judicata, compromise decree, withdrawal of suit, change in circumstances, change in law, erroneous decision, test, interim orders, bar of suit, section 12, foreign judgment, general, foreign court definitions, foreign judgment definition, nature and scope, 5, object, illustrations, jurisdiction of foreign court, binding nature of foreign court, foreign judgments not binding. Section number 13. Foreign judgment not by a competent court, foreign judgment not on merits, foreign judgment against international, foreign judgment opposed to natural justice, foreign judgment obtained by fraud, foreign judgment founded on breach, presumption as to foreign judgment, submission to foreign jurisdiction of the foreign court, foreign judgment res judicata, and conclusiveness of foreign judgment, irregularities not affecting foreign judgment, effect of foreign judgment, enforcement of foreign judgment, suit on foreign judgment, execution proceedings, foreign award, execution of foreign judgment, place of suing, general scheme, pecuniary jurisdiction, general rule, nature, scope, object, mode of valuation, power and duty of court, objection and place of suing, territorial jurisdiction, type of suits. A. Then immovable property, sections 16 to 18, movable property, section 19, compensation for wrong, section 19, other suits, section 20, selection of forum, jurisdiction as to subject matter, place of suing, general principles, forum shopping, objection as to jurisdiction, section 21, general object, objection as to territorial jurisdiction, objection as to pecuniary jurisdiction, objection as to subject matter jurisdiction, objection execution proceedings, 9. Position prior to amendment 76, position after amendment 76, bar of suit 21A, capital A, institution of suit, general suit meaning, essentials of suit, parties to a suit, order 1, general, plaint meaning, joinder of parties, joinder of plaintiffs, rule 1, joinder of defendants, rule 3, necessary and proper parties, non-joinder and misjoinder of parties, rule 9, objection as to non-joinder and misjoinder of parties, rule 13, striking out, adding or substituting parties, adding or substituting plaintiffs, striking out or additional penalties, parties, power and duty of the court, a test, principles, effect, transportation of parties, representative of RAC, and general definition, object enabling provision. As far as practicable, splitting of claim, object, order 2, rule 2, res judicata, interpretation, illustration, conditions, same cause of action, one of several reliefs, leave of court, test, principles, applicability to other proceedings, joinder of claims, rule 4-5, 4-5, joinder of clause of action, rule 3-6, one plaintiff, one defendant, several cause of action, joinder of plaintiffs and cause of action, joinder of defendant and cause of action, joinder of plaintiff, defendant and cause of action. Objections as to institution of suit, order 4, in general, plaint meaning, presentation of plaint, section 26, DR1, particulars in plaint 179, register of suits 179, suit by indigent person 179, suit against minor 179, suit against dead person 179. Procedural law. Laws can be divided into two groups, substantive law and adjective or procedural law, whereas substantive law determines rights and liabilities of parties. Adjective or procedural law prescribes the practice, procedures, machinery for the enforcement of those rights and liabilities. In Halsbury Laws of England, it has been stated there is at the outset a vital and essential distinction between substantive law and procedural law. The function of substantive law is to define, create, or confer substantive legal rights or legal status, or to impose and define the nature and extent of legal duties. The function of procedural law is to provide the machinery or the manner in which the legal rights or status and legal duties may be enforced or recognized by court of law or other recognized or properly constituted tribunal. Procedural laws prescribe procedure for the enforcement of rights and liabilities. The efficacy of the substantive laws to a large extent depend upon the quality of procedural laws. Unless the procedure is simple, expeditious, and inexpensive, substantive laws, however good, are bound to fail in achieving their object and reaching their goals. Procedural law. Now, procedural law is thus an adjunct or an accessory to the substantive law. The two branches are complementary to each other and interdependent, and interplay between them often conceals what is substantive law and what is procedural law. It is procedural law which puts life into substantive law by providing a remedy and implements the well-known maxim ubi jus ibi remedium. The Indian Contract Act, the Transfer of Property Act, Industrial Dispute Act, the Indian Penal Code are instead of substantive law, while the Indian Evidence Act, the Limitation Act, and the Code of Civil Procedure and the Code of Criminal Procedure are instances of procedural law. The Code of Civil Procedure is an adjunctive law. It neither creates nor takes away any right. It is intended to regulate the procedure to be followed by civil courts. History of the Code. Before 1859, 1877, 1908. A litigant, the government decided to bring forward the bill for amendment of the Code of Civil Procedure in 1908, keeping in view inter alia the following considerations. 1. A litigant should get fair trial in accordance with the accepted principles of natural justice. Every effort should be made to expedite the disposal of civil suits and proceedings so that justice may not be delayed. The procedure should not be complicated and should, to the utmost extent possible, ensure a fair trial, fair deal to the poorer sections of the community who do not have the means to engage a pleader to defend their cases. Some of the important changes made by the amendment of 1976 are as under. 1. Doctrine of res judicata is being made more effective. Power to transfer proceedings from one high court to another is given to the Supreme Court. Provision of giving notice under Section 80 before the institution of a suit against the government or a public officer is made less stringent. Restrictions are imposed on the right of appeal and revision. Provisions are being made to ensure that the written statements and documents were filed without delay. New Order 32A has been inserted to provide a special procedure in litigation concerning the affairs of a family. The practice to pass preliminary and final decree in certain suits is abolished. Scope of summary trials is substantially widened. Amendments made in 76 were not found sufficient. With a view to dispose of civil cases expeditiously, Justice Malimat Committee was appointed by the government in pursuance of the recommendations of the committee. The code was amended by the Amendment Act 1996 and 2002. Important amendments made by the Acts of 1999 and 2002 may be summarized thus. In several matters, such as issuing of summons, filing of written statements, amendment of pleadings, production of documents, examination of witnesses, pronouncement of judgments, preparation of decree, etc., a time limit is prescribed. Number of adjournments have been restricted. A provision for recording of evidence by the Court of Commissioner has been made. Endless arguments are sought to be shortened by A. Empowering the court to fix a time limit for oral argument, and B. By permitting written arguments to be placed on record by the parties. A provision is made for filing appeal in the court which passed the decree. Instituting of appeal against the judgment is allowed where the decree is not drawn up. Scope of the first appeal, second appeal, letter patent appeal and revision have been curtailed. Commencement. The Code of Civil Procedure 1908 came into force with effect from 1st January 1909, while the Amendment Act of 1976 came into effect from 1st February 77. It may be stated the Code of Civil Procedure Amendment 1974 passed by Parliament in August 76. Consolidation and codification. The preamble of the code states that the object of the code is to consolidate and amend the laws relating to the procedure of courts of civil judicature. Code of Civil Procedure is a consolidated code as to procedure to be followed by civil courts, as observed in Premlala Nehta versus Chandi Prasad Sekaria. Code consolidates, amends the laws relating to the procedure. Now, extended applicability. Code extends to the whole of India. Object of the code. Object of the code is to consolidate and amend and Scope of the code is not exhaustive. Interpretations, though substantive laws are very important. Value and importance of procedural law cannot be underestimated, but the procedural law must be regarded as such. The function of adjective law is to facilitate justice and further its ends. The rules of procedure are intended to be a handmaid to the administration of justice, and they must therefore be construed liberally and in such manner as to render the enforcement of substantive right effective. Hyper-technical view should not be adopted by the court in interpreting procedural laws. A party cannot be refused just relief merely because of some mistake, negligence, inadvertence, or even infraction of the rules of procedure. Rules of pleadings are intended as aids for a fair trial and for reaching a just decision. An action of law should not be equated to a game of chess. Provisions of law are not mere formulae to be observed as rituals. Beneath the words of the provisions of law, generally speaking, there lies a juristic principle. It is the duty of the court to ascertain that principle and implement it. 23. Our laws of procedure are based on the principle that, as far as possible, no proceeding in a court of law should be allowed to be defeated on mere technicalities. The provisions of the Code of Civil Procedure, therefore, must be interpreted in a manner so as to subserve and advance the cause of justice rather than to defeat it. The principle underlying interpretation of procedural laws has been succinctly laid down by the Supreme Court in the case of State of Punjab versus Shamlal Murari. Sorry.